Hey, Brian Parker here with another great video on private student loans when you're facing a Sallie Mae or a Navient student loan lawsuit. They're really quite easy. They're just debt buyer lawsuits. The two mantras you're going to hear in this video are: number one, even if you owe the debt, I'm going to show you why you don't owe it to the company suing you. And number two, use their own documents against them. That's my mantra through all my videos. Number one thing you're going to look at is that this is an old debt. So it has statute of limitations issues. But the beauty in these lawsuits against you, you should actually be elevated and happy because their complaints are such schlock and nonsense that you can use it against them. For example, here's a case I'm currently working on right now. And in that case, SLM Private Education Loan Trust 2011-C is suing my client with the wrong name, by the way. And they are saying that, quote, prior to the commencement of this action, plaintiff, which is SLM Private Education Loan Trust 2011-C, plaintiff acquired the defendant's account from SLM Private Education Loan Trust 2011-C. How does it take it from itself, and why is that in the lawsuit? Nobody will explain that to me. 10 months later, I still have no explanation, but I know why. And they won't change it because there's a greater lie going on here as far as the mismanagement of trusts and the fact that SLM is part of an organization that split up, meaning Sallie Mae and Sallie Mae Bank in 2013 split up, and they each took their own parts of whatever they claimed was theirs. Sallie Mae, the entity separate from Sallie Mae Bank, became Navient, and that's just turned out to be a giant mess. I've deposed them several times, and it's always fun. You'll notice when I mentioned this pleadings, and it's paragraph 4, I'm going to put it on the screen right now, Shazam, and that's the complaint, and I've circled it, and you can see they're claiming they bought the thing from itself. But what did they buy? Did they buy a debt that they're now suing you upon? No, they are buying what's called, if you look, plaintiff acquired the defendant's account. Why not just say they acquired a debt? The definition of an account is a record or statement of financial expenditure and receipts relating to a particular period or purpose. A debt is something, typically money, that is owed or due. Why is the word debt not in anywhere of this lawsuit? Because they do not own the debt. They own a piece of paper that says some payments were made, now you try and collect from this person. After, in my case, going through 10 separate entities. Look at your average Sallie Mae promissory note. This is your tip number 2. I'm going to put one up on the screen for you. Shazam. To the left, you'll see the word lender. Here is where whoever lent the money to my client, their name is placed. What's important about that? Because they're the originator of the debt or the original creditor, and that's who this company, SLM Private Education Loan Trust, is going to claim they got the debt from. They didn't in their lawsuit, but that's where it has to start. They don't even have the name. What's important about that? You can't finish if you didn't start. So you can't prove a chain of title when there's no original creditor. That's important. Any link break in the chain of title means you win. They can't have standing. Number 2, most promissory student loan notes from Navient or Sallie Mae or Sallie Mae Bank have what's called a choice of law, governing law provision. I'll put this one on the screen, Shazam, and you can see that the state of where the lender is located is where the state law is used or imposed to sue somebody that's in default. There is no lender, and even if there was, it's Utah is the governing law. That's where Sallie Mae is out of at this point. This case is brought in Florida, and they all are brought in different states. That's a defense. You're not following your own contract, yet you're claiming I'm breaching it. So that's a great defense. Number 3 tip, look for the broken chains of title. All you need to do is show one link. Here there are 10 entities. You just got to show that your debt, and there's no proof of your debt, your name, your account number following. They'll have a ton of companies saying, we gave it to this person, we gave it to this person, but nothing proving your debt flowed with whatever assignment they claim happened. Fourth important tip is your counter affidavit. Everything that you find wrong with this lawsuit, with the documents, anything else in this matter must appear in your counter affidavit. To not have a counter affidavit is like not answering the lawsuit. Why? If they have an account stated claim against you, they bring an affidavit. In a lot of states, not answering the affidavit with a counter affidavit is the same as not answering. You will be found in the default a little later than if you hadn't answered the lawsuit. But most states have a presumption of you owning or owing the debt if you did not answer the affidavit. I've seen it in plenty of Supreme Court decisions. Number 5, look at that split between Sallie Mae Bank and Sallie Mae. It caused an awful bunch of information problems. In my case, just the one I'm looking at today, my client's name she hasn't gone by that name in over 10 years. I've pointed that out to the fine folks that are representing SLM Private Education Loan that wrote the lawsuit. They don't want to hear it. I say, you got the wrong person. It's not going to work. Nope. I said, you're suing on behalf of someone. You sold yourself the debt. No, we didn't. I don't want to hear it. It's very legally weird what they're doing. So in conclusion, look at the statute of limitations. When did you last make a payment? In California, if you haven't made a payment in, I think it's 4 years, you win. They can't sue you. Look at the assignments. Did the numbers, did your name follow through this weird falsehood of assignments and transfers? Who really owns a debt? You'll never know in one of these cases. Look at the pleadings. They will help you. It will make it easy for you to win and win your counterclaim and get a check, get the whole debt eliminated. It's already gone anyway. Look at the actual loan documents. They're your friend too. Again, if they're breaching their own contract they claim they're owed, they can't have what's called clean hands in law. You can't accuse somebody of something if you've got dirt under your fingernails. You've got to have clean hands. Research that split. Research Google all the numerous trusts. And if you can somehow prove to me that an account is the same definition of debt, they're not, then I've got a lawsuit for you to believe in. Why is in your lawsuit and every other stated lawsuit not coming with the word debt? Isn't it a debt? Because it doesn't exist any longer. Use the paperwork, use that information, look at all my other videos, look how to create a counter affidavit. Up on the ceiling of this video will be all my numerous affidavit videos, killer affidavit, etc. But the counter affidavit is everything. Everything I just told you should be in that after you tear apart the lawsuit. So go get them. You'll do great and you'll get out of this debt. Thank you.